Get ready for the dictation. Start. Issue number 5 pertains to attestation of the petition not being made properly. The objection raised by the appellant to the maintainability of the election petition was that only the front page of the election petition had the words attested to be true copy. Issue number 5 was answered in favor of the respondent. The High Court considered the main controversy pertaining to the filing of false affidavit regarding the educational qualification by the appellant in a detailed manner. There is no doubt that the appellant filed Form 26 in which he mentioned his educational qualification as MBA from Mysore University in 2004. After careful consideration of the material on record and various judgments cited by the parties, the High Court concluded that the declaration made by the appellant in Form 26 about his educational qualification as MBA from Mysore University was false. The plea of the appellant that the defect in Form 26 was due to a clerical error was rejected. The contention of the appellant that providing wrong information about the educational qualification was not a defect of substantial character was also rejected. The appellant contended that the respondent failed to plead and prove that the result was materially affected, as required under Section 101D of the Act. The High Court did not accept the said contention on the ground that there were only two candidates in the fray, in which case it was not necessary to prove that the result of election of the returned candidate was materially affected. The High Court further held if it is found that the appellant's nomination was improperly accepted, the result of his election stood automatically affected materially. The High Court, on the basis of the above reasons, declared the election of the appellant as void. The appellant has filed this appeal challenging the same. We have heard Mr. V. Giri, learned senior counsel for the appellant, and Ms. Meenakshi Arora, learned senior counsel for the respondent. Mr. Giri submitted that the declaration pertaining to the educational qualification of the appellant was merely a clerical error and cannot be termed as a false declaration. In any event, the declaration of educational qualification is not a defect of substantial nature warranting rejection of his nomination. Mr. Giri also submitted that the election petition was filed under Section 101D first and 4th of the Act. He stated that there is neither pleading nor proof in the election petition that the improper acceptance of the appellant's nomination had materially affected the result. According to Mr. Giri, the appellant's election cannot be set aside on the ground of improper acceptance of his nomination without the requirement of Section 101D of the Act being satisfied. He referred to Durai Muthuswamy versus N. Nachiyappan and others, reported in 1973 to SCC 45, and submitted that the said judgment should be restricted to the facts of that case. He also attempted to distinguish the said judgment as not applicable to the facts of this case by submitting that it was a case of disqualification under Section 9A of the Act. He further submitted that the said case was one filed under Section 101A of the Act. He contended that there is no need for pleading or proving that the result was materially affected if the election is challenged under section 101A to C, whereas it is compulsory in a petition filed under section 101D. Ms. Meenakshi Arora, learned senior counsel, argued that the respondent pleaded in the election petition that the result of the election was materially affected by the improper acceptance of the nomination of the appellant. She took us through the pleadings and evidence, both oral and documentary, to contend that the declaration of educational qualification by the appellant was not a mistake. She submitted that the same declaration was made by the appellant even when he contested the earlier election to the Legislative Assembly in 2008. She also highlighted the contradictory stands relating to the declaration taken by the appellant. She submitted that it was not necessary to show that the result of the election was materially affected when there were only two contesting candidates for one seat. Stop.